So we're on the record in docket 21-03378. People of the state of Michigan versus LaShawn Brown. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Mr. Brown.
And sir, you are LaShawn Brown?
Yes, sir.
All right. This is the time set for jury trial today. Mr. Wisty, how are we proceeding?
Your Honor, we'd be proceeding with trial.
Okay. So we'll tell Susan to call in a jury. And I don't have the file because it was in the warrant drawer because we have a material witness warrant. Ms. Robinson, is that your understanding we're going to trial today?
Yes, it is, Your Honor.
All right. Then we'll double check the jury instructions that we've written up previously, and I'll let each party look at those. But I'll make a note in the file, and then we'll see what other things we can move this morning. Okay.
Sounds good. Thank you.
All right. Thank you.
So, Mr. Brown.
And then, Your Honor, just so the court is aware, I checked to have my office.
What's that?
My officer hasn't arrived yet. What time do we need before the jury is?
Generally, I think we call the jury in at
They're calling at 9, and I think they have to report by 10.
10.
But don't hold me exactly. to
All right.
that.
So
I have no reason not to expect that he'll show up.
right. I let us know by 9 what the status is, and so definitely by 10, but by 9, just so we can anticipate. I don't want to call the jury in and find out that we're missing somebody.
Thank you, Your Honor.
Okay, thank you.
We didn't even know before
All right.
8:45 is the cutoff.
So 8:45 is the cutoff. All right. So yeah, I'll keep an eye on the time while I'm on the bench, but and if you need to leave, let me know just to contact them.
Thank you, Your Honor.
It's a police officer. So.
Sorry.
Sir, you're Scott Patterson.
Yes, sir.
All right, you're in the right room. We're just gonna give about 5 minutes to see if any witnesses show up, okay?
Yes, sir.
All right. And your lawyer, Ms. Sutter's here also.
Okay.
I have.
So Mr. Chernich, you're here on Case Credit Union?
I am,
All right, and we're waiting for Michael Scusa.
correct.
Okay, thank you.
Thank you.
Ms. Green, you're here for your 8:30 pretrial? You're gonna have to unmute yourself, ma'am.
Yes,
All right, and your attorney is Kenneth Scott?
yes.
All right, stand by. We're waiting on Mr. Scott's appearance, okay?
Thank you.
And Mr. Anderson, you're here for Joshua Smith? Mr. Anderson, you're here for Joshua Smith?
I am, Your Honor.
All right,
Can you hear me?
and I can, thank you.
Thank you.
All right, so we're just waiting on the plaintiffs in the case at this point, and Mr. McCants.
Yeah, I guess so.
All right. So we're on the record in docket 22-02740 and 22-02980. People of the state of Michigan versus Scott Patterson. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Patterson, who is present with us via Zoom.
And sir, you are Scott Patterson?
Yes, sir.
All right, you can hear me all right, Mr. Patterson?
Yes, sir.
All right. time set for a final pretrial on both of these files. Mr. Wisty, how are we proceeding?
Your Honor, people's witness has failed to appear. We will be dismissing the cases.
All right, this was set for 8:30. You don't anticipate,
I do not anticipate
Okay.
this being here.
so dismissed without prejudice. If your witness shows up, of course, we can revisit this, but
Thank you, Your Honor.
There's no objection, Your Honor.
all right. So without objection, I take you've had no contact with the witness at this point in time.
Had contact and she's indicated she didn't want to.
Okay, yeah. All right, so Mr. Patterson, both files have been dismissed at final pretrial for the victims, for the complaining victims failed to appear. So that means without prejudice means that it could be brought back by the prosecutor with additional information, although for today's purposes, the case is dismissed. Do you understand that, sir?
Yes, sir.
All right. Anything else for the record in docket 22027440 or 22029880? Mr. Wisty,
Nothing from the people.
anything, Ms. Sutter?
No, Your Honor.
All right, that's all for the record, both of those files.
You're all set to go,
Yeah.
Mr. Patterson.
May I ask one question? The last time I was here, I had a court date of December 5th. Do I still have that court date?
We goes to jury trial.
That was the jury trial?
Yes.
So I think that's dismissed as one of
Yes.
these files. So that date is one of these files and that's been dismissed.
Okay, so I will be able to get out of here today? Or whenever?
If you're only here on these two files, the answer is yes.
All right. Thank you,
Okay.
Ms. Sutter.
You're welcome, Mr. Patterson.
May I approach, Your Honor?
You may, Mr. Wisty.
Thank you, Your Honor.
So I'm all finished, right? I can leave?
Yes, you're free to go.
Thank you.
This is Benali. All right, we're on the record in docket 2202-947. People of the state of Michigan versus Michelle Simmons. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Ms. Simmons, who is seated to my right.
And ma'am, you are Michelle Simmons?
Yes, sir.
All right. This is the time set for a final pretrial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, the people's witnesses have failed to appear this morning. For that reason, we will be dismissing at this point without prejudice.
No objection, Your Honor.
All right. Ms. Simmons, what that means is without prejudice means that the prosecutor could bring in with new information the case back to reissue. But as for all intents purposes, the case is dismissed today, okay? All right. Anything else for the record, docket 2202-947, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, that's all for the record. Good luck to you, ma'am.
Is there any sign of Mr. Scott?
I do not see Mr. Scott.
So I would, I guess, leave that in the court's discretion. We did reach a resolution involving Ms. Green claim restitution, which I just received paperwork indicating she did. So it would be my intent to dismiss the case based on that.
Well, based on that, I think we could, if Ms. Green allows, or Ms. Green, but we can proceed without, since you're moving to dismiss, but let's, let me get her. So Ms. Green, can you hear me?
Yes.
All right. We've got about a minute to give to your attorney. It's my understanding that the prosecutor has received information that restitution's been paid in this matter, and they're going to move to dismiss. Did you want to proceed without your lawyer today and just for the dismissal purposes, or did you want to wait? Okay, all right. So I'll go ahead and call that. I'll go ahead and call that for the record, and then we can just put it. We can put it. We can put that on the record. So this is docket 2202-568. People of the state of Michigan versus Shalanda Green. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And ma'am, you are Shalanda Green.
Yes.
Okay, and you are represented by attorney Kenneth Scott, who is not present today. And we're about 15 minutes from the date and time. You and I have had some opportunity to discuss this matter. You understand this is going to be a dismissal today?
Yes.
All right, and you're good with going forward without Mr. Scott present?
Yes.
All right, Mr. Wisty, how are we proceeding?
Your Honor, the people will be dismissing in the interest of justice. That is the victim's desire, and the defendant has made restitution.
All right, so Ms. Green, you understand that the people are moving to dismiss without prejudice in the interest of justice. They've had contact with the victim and their understanding, and the victim has indicated that restitution's been made in this case?
Yes.
All right, and so you understand that the without prejudice means that the court, the people could at some future date bring this case back with additional information, but for today's purposes, the case is dismissed. Do you understand that, ma'am?
Yes.
All right.
May I approach, Your Honor?
You may. So I'll sign that Nolly Pros.
And then I have one on Simmons as well.
All right. And Ms. Green, you should be all set today, okay? And then we'll let if your attorney appears late, and you can contact your attorney, but we'll let him know what occurred here, okay?
Thank you so much.
All right, thank you, Ms. Green. That's all for the record in docket 220568. You're all set, ma'am.
You have a good day.
You too. Mr. Chernich, do you want to go on your file? That's docket 14-00790 GC Case Credit Union versus Michael Scusa. Will the parties please introduce themselves for the record?
Sure. Good morning, Your Honor. Scott Chernich on behalf of Case Credit Union.
And this is by Zoom conference. It's set for discovery. I don't see Mr. Scusa in the courtroom. He's certainly not in the Zoom courtroom. This was scheduled for 8:30. It's now 8:48. Mr. Trinich, how would you like to proceed today?
Well, we've got proof of service. Apparently, Mr. Weber at Risk and Associates served the defendant on November 18th at 3:25. That was personal service. I don't know what the court preference is here, whether it would set a show cause hearing or simply issue a bench warrant, whichever is the court's usual.
I think, yeah, I think for this, I think we'll show cause Mr. Scusa as to why he's failed to appear today, and then we'll go from there.
That's I appreciate that. Thank you.
All right, so at this point in time, the defendants failed to appear. And we'll show cause Mr. Scusa on his fail to appear today. And then once we get notice of that, we'll proceed in this matter, you know, assuming we can find him. But I do have personal service in this. I do have personal service. I initially didn't, and then I have it. It came a little later.
Understood.
All
Will
right.
the court
So that's all-
will the court be serving the notice?
No, we won't. We'll set it for show cause, but we won't. I don't think we'll serve him.
All right, we'll serve it as soon as we get it then.
All right.
Thank you,
Anything
Aaron.
else for the record docket 1400790, Mr. Turnich?
No, Your Honor. Thank you very much.
Okay, thank you. Thank you for your appearance today. That's all for the record in this file. And then Mr. Anderson
Yes,
and Mr. Asphalt, you're here on, are you here on the Cedar Creek?
I am, Judge.
All right. So let's go ahead and call that. We're on the record docket 2201056. That's Cedar Creek versus Joshua Smith and Isaiah McCants. Now I just have Joshua Smith. I don't have Mr. McCants.
Yes.
So
good
let's,
morning.
so the parties please introduce themselves for the record.
Christopher Asphalt, 53129 for the plaintiff.
All right.
Thomas M. Anderson, P 10188 on behalf of Joshua Smith.
All right. This is the time set. I have it set for discovery matter. Mr. Asphalt, how are we proceeding today?
Well, Your Honor, I mean, at this point in time, discovery has been essentially completed. I guess you can just set the matter for a trial date. I'm hopeful the parties can settle the matter before then.
And is Mr. McCants still a part of the litigation here, or is that, because I don't have Mr. McCants here, but I don't have him as a part of the notice.
Yeah, I don't think he's part of this case, Judge.
Okay.
Yeah, well, Your Honor, I'd like to speak to that point, okay?
Okay.
The pleadings that are filed on behalf of Joshua Smith would lead, and the discovery would lead to a necessity for filing a third-party complaint against Mr. McCants. Now, it's pretty clear that what happened is my client was giving the money to McCants to pay the rent, and Mr. McCants did not do that. Now, when he was served, there was a default taken. There's a default judgment that has been entered. And Mr. Asphalt, I believe, has been following up with garnishment procedures. The last I knew, there was an $800 balance on a $2,000 judgment. And frankly, I'd like to know what the status is as far as the current collection activities on behalf of Cedar Creek.
Your Honor, I can confirm now that Mr. McCants was a part of this lawsuit, and there was a default taken on him. I've been in contact with Mr. Anderson frequently. The latest balance that is owed is $373. So we've been able to collect where we have a garnishment on Mr. McCann's. Mr. Smith is obviously also liable for this debt. If you want, I've been making him offers to, if he wants to pay a couple $100 to get rid of this case, he can. Otherwise, we can go forward with our trial, or maybe the case will be, the debt will be paid off by the next trial date. I don't know, Judge, but that's the situation.
Okay.
Judge,
Um,
it sounds to me like they're being very successful. If I heard correctly, they're down to $317. The last time I talked to Mr. Asphalt, it was $800. That was about a month or 6 weeks ago, maybe 2 months ago. So I'm hoping that what you can do, Judge, is set this matter for trial sufficiently far out. So, and I'm hoping that Mr. Asphalt's insistence on keeping us in this case, given the fact that he's successfully collecting on the judgment, he'll continue to do the garnishment. That's what I'm hoping. I understand where he's coming from, but at the same time, he ought to cut us some slack too.
Well, I am.
Mr. Asphalt, do you have any objection to setting this for jury trial, but setting it out? I would think a couple months at least.
That's fine, Judge.
Yeah. All right, let's set a jury trial date, and we'll set it in the future so to see the status of the case in regards to some of the collections on the co-defendant, which would seem to have impact concerning the debt owed by your client, Mr. Smith. Let's set it for March 15th.
How about April 15th? I want to give them plenty of time to collect their money.
Let's see, December, January. Yeah, let's do March 15th. We'll give March 15th a try because I think we'll lose control of the case a little bit. So March 15th at 8:30.
Now, Judge.
And in the meantime, the parties can stay in contact with the court and let us know
Let me ask you this. Judge. I'm sorry.
Go ahead, Mr. Anderson.
I would like to reserve the right to file a third-party complaint. That's what I've been trying to avoid. I've been trying to save the clients some attorney's fees here. And I want to be able to file a third-party complaint, but I don't want to go through with it. As I said, they've collected, it was a $2,200 judgment. They're down to $315 now. So things are moving along fairly well, I gather. And so all I'm saying is that if we end up having to go to trial on this matter, I want to be able to file a third-party complaint against Mr. Smith.
But yeah, I understand. Let's see, we have December, January, February into the middle of March. That should give you the time, Mr. Anderson, you need.
Okay, I appreciate it.
All right. So so this is set for jury trial and concerning this file, and understand it has somewhat other implications. But we'll set it for March 15th at 8:30. Anything else for the record, Mr. Asphalt, and docket 22-01056?
No, Your Honor.
Anything, Mr. Anderson?
Thank you, Your Honor.
Thank you, Judge. Thank you, Mr. Anderson. We're all set on this file.
Okay.
You are unmuted.
Hi, Stewie, this is Lauren Sutter. So you entered your
Hey.
NGRI plea. You entered your NGRI plea last week with Judge Kennedy. The prosecutor in this court filed the dismissal about 20 minutes ago.
Okay.
So it went exactly as we kind of thought it would. The plan played out. Your case in this court was dismissed, so you're free to go. You don't need to stick around.
What's going on with my the forensic center and stuff?
Last I heard, about a 1 to 2 week wait for your placement. So not as long as we thought.
Cool.
We'll schedule a polycom to talk with you more about that. We're in the courtroom right now, so I'm not gonna have a fully in-depth conversation with you, but I'm sure Ms. Schroeder will schedule a polycom with myself and Maria to talk more about that in a little while before that placement, but it's a much shorter time frame than we thought it might be.
That's awesome. What about the Eaton County stuff?
Don't know about that. We'll look into it and meet with you over polycom to talk about it.
All right. Thank you, ma'am. Have a good day.
No problem, Stewie, you too.
Yep.
proceed on it, whatever.
So we're on the record, docket 22022485, People of the State of Michigan versus Megan Gearhart. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Ms. Gearhart, who was present with us via Zoom.
And ma'am, you are Megan Gearhart?
You're-
You're gonna have to unmute yourself, ma'am.
Yes,
And you can hear me all right, Ms. Gearhart?
yes, I can.
This is the time set for a pretrial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, negotiations are continuing. One of the conditions was Ms. Gerhart get a substance abuse assessment. I've been informed by defense that she has in fact had that done at Mid-Michigan Recovery Services on the 16th of November. However, defense has not obtained a copy of the report, which I would like to review before making an offer in this case. We'd be requesting an adjournment for 2 weeks. The idea being that would be good enough turnaround time for Mid-Michigan to get the information to defense counsel.
Ms. Sutter, is that your understanding?
It is, Your Honor.
So let's go ahead and set it for final pretrial, because we set it for, this was just set for the second jury trial, and we're still waiting on the report for the assessment,
That's correct.
because the assessment's been completed.
Yes.
So let's go ahead and set it just a standalone final pretrial.
It is gonna be Thursday, December 15th at 1:30.
So that's 2 weeks.
Thursday, you said?
We had to get a little creative with some statute time.
Thursday, December 15th at 2:30?
At 1:30.
At 1:30, okay. So Ms. Gearhart, you understand that we're adjourning this for the assessment report, and we'll reconvene on December 15th. That's a Thursday at 1:30.
Yes,
All right,
And Your Honor, I believe we would stipulate that there are no witnesses needed by the state.
correct. Mr. Wisty, is that your understanding?
That would be my understanding.
All right. No witnesses needed. And this can be a Zoom final pretrial
Thank you.
since this is not an assaultive crime. Right. Mr. Wisty, anything else for the record?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, Ms. Gearhart, we'll see you back here on Thursday, December 15th at 1:30.
all right, thank you.
All right.
In the back. That's fine.
And
For you, Mendenhall, Your Honor.
which one?
Mendenhall.
Mendenhall. We're on the record in docket 20-01193. That's People of the State of Michigan versus Darian Mendenhall. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Mendenhall, who joins us via Zoom.
And sir, you are Darian Mendenhall?
Yes,
You can hear me all right, Mr. Mendenhall?
yes.
All right, this is the time set for a pretrial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, we'd like to set for a final pretrial and jury trial date.
Okay, so this will be set for final pretrial and jury trial. Is that your understanding, Ms. Sutter?
It is.
Okay.
January 3rd
For final pretrial?
at 8:30
Okay.
and January 17th for trial.
8.
At 8.
So it's set for final pretrial on January 3rd at 8:30, and it's set for jury trial on January 17th at 8. So the final pretrial and jury trial will be here live in person, Mr. Mendenhall. And that'll be on January 3rd at 8:30. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, so we'll see you live in the courtroom on January 3rd at 8:30. All right, sir?
Thank you.
Okay, thank you. That's all for the record in that file.
You're all set to log off, Mr. Mendenhall. I'll give you a call when I get the report.
Okay, thank you.
don't know who's in the jail mobile. Is that Philip Stewart?
He already logged in and I told him the case was null and let him go. He was an
Okay.
ICJ, so I don't know who this one is.
Oh, that's Tracy Deer. So Philip Stewart is nollied.
Yes, if I may approach, Your
Yeah.
Honor. This was nollied as part of the global resolution of Circuit Court. I got confirmation that went through
All right,
yesterday.
that's all right.
If I may briefly excuse to check for witnesses.
Absolutely.
You have Tracy here.
I do not. Oh, yes, I do. I lied.
There's Stewart.
Sorry if I jumped the gun on letting him go earlier on. I wasn't.
No, you're
my-
good.
My conversation with him made me think he'd already filed the nolly.
No, that's all good. Okay, that's Annette Smith.
Yes. And she's ready to go. I think Mr. Wissing is just checking on witnesses for her.
All right, and then Crenshaw and Keys are the two. Are they FTAs?
I've spoken with Brittany Crenshaw. Somebody from my office has spoken with her and I've emailed her this morning. She's feeling quite sick. I already spoke with Mr. Woody. Our plan was, Mr. Wisty, our plan was to request a jury trial. Or, I'm
Okay.
sorry, an adjournment. I
Okay.
can't speak today.
That's
So
the
if it's all right with-
valid ops.
Yes, and if it's all right with the court, I was going to waive her appearance. She has been in communication with me this morning regarding an illness.
I don't have any, dog in the fight, really. If Mr. Whiskey indicates. on
Crenshaw.
Crenshaw, I'm sorry.
Yeah.
Yes, we talked about a 2-week adjournment on that to give her a
Okay.
chance to take the test again.
All right, let's call that then. So we'll call to the record docket 1505372. That's people of the state of Michigan versus Brittany Crenshaw. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing today on behalf of Ms. Crenshaw. I'm going to be waiving her appearance today.
Yeah, it's my understanding that Ms. Crenshaw has been in contact with her public defender, and there was a request for compliance purposes that Ms. Crenshaw's sick today, essentially.
Yes.
And so we'd be looking for a second pretrial date for compliance purposes. Is that correct, Mr. Wisty?
Yes, Your Honor.
Okay.
And just for the record, this may be the second pretrial.
I think this is, so let's set it for, so we're 30 days out for compliance purposes. So I think an additional couple weeks.
Yes, Your Honor.
I mean, what do you think?
I mean,
That-
basically, she's got to take the test and hopefully she passes.
Right.
And I'd rather have her get a driver's license.
Right.
Out of this.
Well, let's set it.
She's at.
We have like a date. When, does she have any indication when she's taking the test?
The email she sent me Saturday night indicated that she had taken it, was unsuccessful, and was hoping to reschedule it again. I do not know that she had a firm date when she emailed me on Saturday when that would be. My only communication with her this morning was regarding her illness.
Okay.
Correct. I believe it's relatively quick to get scheduled to take that portion of the test.
Right.
So-
It's the computer test she has to take.
All right. So set it 30 days.
Is that acceptable to the people, Your Honor?
Okay, just do 30 days out.
January 3rd.
January 3rd. So it did not sound very definitive.
I was making sure.
January 3rd at 9 a.m. for a second pretrial. D to take. Computer test. All right, anything else for the record in docket 1505372, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right. And then, is it Delana? Is that an FTA?
I believe Ms. Robinson is checking on that. That's her
Okay.
compliance.
I don't have her represented, so that must be,
Yeah, Wendy and I were discussing that earlier. Our office filed an appearance on the 16th. It looks like it hasn't been received by the court yet.
Okay.
It is assigned to Aaron Robinson.
Aaron Rowe, okay.
And we can
You want to,
refile the appearance if that's necessary.
how about Miss Smith? Are we ready on Miss Smith?
Yes, Your Honor.
So on the record in docket 22-02719, people of the state of Michigan versus Annette Smith. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter appearance on behalf of Mrs. Smith, who is seated to my right.
And ma'am, you are Annette Smith?
Yes.
All right. This is the time set for a final pretrial in the matter. Mr. Whiskey, how are we proceeding?
Your Honor, witness has failed to appear. As a result, the people will be dismissing without prejudice.
No objection, Your Honor.
Okay. Do you have a nollie pros to that effect? You just printed it, okay. So Ms. Smith, what that means today is the people are moving to dismiss without prejudice, which means they could bring the file back in the future. But for all intents and purposes today, the case is dismissed, all right?
Go ahead, Your Honor.
You may. Thank you. Anything else for the record in docket 22-02719, Mr. Whiskey?
No, Your Honor.
Anything, Ms. Sutter?
I apologize, Your Honor. Can you say that again?
Anything else for the record, Ms. Sutter?
No, Your Honor.
All right. Ms. Smith, you're free to leave.
Thank you.
Thank you.
Sorry, did you have Tracy in here?
I do have Tracy here.
Tracy, serious charges.
And shut up. Those are all 10 o'clocks. So Ms. Robinson, you have Miss Keys?
I do.
All right. I don't think so.
Okay.
So on the record in docket 22-03125, people of the state of Michigan versus Delana D. Keys. This is the time set for pretrial in the matter. Would the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Aaron Robinson, Assistant Public Defender for Ms. Keys.
And this was set for 9:30. It is now 10:15. And I don't see Miss Keys in the actual courtroom or Zoom courtroom. Nathan, you might want to check the hall just to see if anybody's there.
I did.
Nobody's out there? All right. So it appears that Miss Keys, what's that? Oh, on the iPhone. Well, let's see who this person is on the iPhone. Person on the iPhone, would you identify yourself?
My name is McKenna Decker.
Okay, Miss Decker, you're here for your 10:30?
Yes.
All right. You're in the right place, ma'am. Just stand by, okay? We've got a couple cases in front of you, okay?
Okay, thank you.
All right. Mr. Whiskey, it appears that Miss Keys has failed to appear today. How would you like to proceed?
Your Honor, I'd request a bench warrant. This is an assaultive crime, so without the 48-hour hold.
Ms. Robinson?
Your Honor, I would request a 48-hour hold in this case. I understand that it is an assaultive crime. However, I believe that the law gives you discretion. It looks like I have on file a Detroit address, so I'm not even sure if the notice would have gotten to her on time.
Yeah, I'm not. I have a Lansing address as a part of this, but I also have a Detroit address. It's 3 counts of assault and battery. So I'll issue a bench warrant and bond forfeiture. DFTA. No no 48-hour hold because of the assaultive nature. Anything else for the record, Mr. Wisty, on docket 2203-125?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor,
All
thank
right,
you.
thank you. That's all for the record in that file. And then it is.
Go on the record, so whenever.
Are you ready, Mr. Wisty, on Ms. Decker?
Yes, Your Honor.
All right, Ms. Decker, we'll go ahead and call your case.
Okay, yes, you are.
All right, so we're on the record in docket 2203-232, 03232. People of the state of Michigan versus McKenna Decker. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender for Ms. Decker, who's appearing over Zoom.
Ma'am, you are McKenna Decker?
Yes, yes, Your Honor, I am.
Okay, and you can hear me all right, Ms. Decker?
Yeah.
All right, this is the time set for pretrial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, at this time, we'd like this set for a final pretrial and jury trial.
Okay. And is that your understanding, Ms. Robinson?
It is, Your Honor.
The final pretrial date will be
January 3rd at 8:30
January 3rd at 8:30,
and the jury trial 17th at 8.
and the jury trial will be January 17th at 8. The final pretrial will be live, Ms. Decker, so you should come in person for that final pretrial on the January 3rd. And then depending on what happens there, we'll set it, it'll be set for jury trial on January 17th. Anything else for the record, Mr. Wisty, on docket 2203-232?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right. So Ms. Decker, we'll see you back here on January 3rd at 8:30, okay, ma'am?
Okay, January 3rd at 8:30 in person
30.
and
In person.
the 3rd?
Yes. Yeah.
And what's the 17th for again?
Jury trial. So you have a final pretrial and then you have a jury trial date on January 17th. So depending on what happens at the final pretrial, the jury trial's already been set.
Okay, so am I allowed to hang up or you want me to stay on? Hang up now?
Nope, you're free to leave for today's purpose, Pam.
Okay, so I'll see you January 3rd at 8:30.
Sounds good. Thank you.
You're welcome. Have a blessed day.
You too. Sir, you're Tracy Deer?
Yes, sir.
All right, I'm gonna place you in a breakout room with your public defender, Lauren Sutter, okay?
Who?
Mr. Deer,
Yes.
you have a public defender on this misdemeanor pretrial, and I'm gonna go ahead and place you in a breakout room with her, all right?
All right. 'All right. All 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 right.
Okay. All right, we're on the record in docket 22-01219, people of the state of Michigan versus Tracy Deer. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Deer, who is joining us via Zoom today.
And sir, you are Tracy Deer?
Yes, sir.
Okay, and you can hear me all right, Mr. Deer?
Yes.
All right, Mr. Wisty, this is the time set for a pretrial in the matter. How are we proceeding?
Your Honor, we'd like this set for a final pretrial and jury trial date.
Okay, we'll set it for final pretrial and jury trial.
January 3rd at 8:30.
The jury trial, the final pretrial will be January 3rd at 8:30
And jury trial the 17th at 8.
and January 17th at 8 for the final jury trial, or the jury trial. So we'll be back here on January 3rd at 8:30 for the final pretrial, January 17th at 8 for the jury trial. Anything else for the record, Mr. Wisty?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
Mr. Deer, we'll be back here on January 3rd at 8:30 for the final pretrial. Please keep in contact with your attorney, Ms. Sutter, if you have any questions. All right, sir?
Yes, Your Honor.
All right. So that's all for the record docket 22-01219. Mr. Deer, you're free to leave the Zoom courtroom.
All right, thank you.
And let's go ahead and call shot. So we're on the record in docket 22-02821, 822, 823, 824, and 825. People of the state of Michigan versus Randolph Schaub. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Schaub, who I do not believe is present.
This is the time set for a pretrial in the matter. Mr. Wisty, and for the record, there are 5 files, and we've received an appearance on one of the files, but my understanding in the computer would indicate that Ms. Sutter, you represent Mr. Schaub on all the files.
Yes, Your Honor. I do represent him on all the files, and my office will be signing my appearances and the remaining ones later today.
Mr. Wisty, this time set for pretrial. It appears the defendant has failed to appear. It was scheduled for 10 o'clock. It's now 10:35. How would you like to proceed?
Your Honor, people would request a bench warrant, and I would give the court's discretion for a 48-hour hold, given the nature of the charge.
All right, Ms. Sutter?
Your Honor, I would just ask that a 48-hour hold be put in with any bench warrant being issued. My understanding is this is his first failure to appear, and while there is perhaps an allegation of a harm done, it's not by him as a person.
Right. I don't see this as an assault of crime, although there is a dog bite as a part of these files. But we will indicate the defendant failed to appear. Bench warrant bond forfeiture issued with a 48-hour hold on the bench warrant bond forfeiture. This is the first fail to appear, and it's a nonviolent crime.
Thank you, Your Honor.
Anything else for the record in dockets 2821, 2822, 23, 24, and 25, Mr. Wisty?
No, Your Honor.
Anything else, Ms. Sutter?
No, Your Honor. Thank you.
Wait, overall. I'm gonna write that in all these. All right, so we've gone through the challenges for cause for the people. We've had some discussions concerning some challenges here. So I'll indicate for the record that Mr. Lee, you're excused. Yeah, you're excused today. So you can step down from the juror panel. And we'll replace Mr. Lee with Philip Seaman. Sir. The other, and I'll question Mr. Seaman. Ms. Starling, you understand that the court's going to give you the law to follow, and then within the best of your ability, you will follow whatever instructions I give. Do you understand that, ma'am?
Correct.
And would you be able to do that?
I believe so.
Okay, thank you. Mr. Seaman, you had the opportunity to hear all the questions asked.
Yes.
Right. Do you have any responses that you think the jurors should know in regards to any of the litigators should know in regard to any of the questions asked of the former jurors?
No.
Okay. Mr. Wisty, any questions for Mr. Seaman?
Yes, Your Honor, but I would like to basically ask you the other questions in more detail if it would allow for that.
A summary of them, yes.
And Mr. Seaman, how are you doing? So we had gone over what is reasonable doubt. You understand that would be common sense, reasonable doubt. Do you have any issue with that concept? Nothing. Any questions about that? We've gone over police officers. Do you have any particular bias for or against police officers? No. And have you ever been in trouble with the law before? No. You ever been a victim of a crime before? No. And we have discussed when it would be appropriate to leave children home alone. Do you have opinions on that?
Just as the jury stated, there is a certain age I feel that a child is unsafe to be left at home.
I have no further questions, Jonathan.
Ms. Robinson, any questions of the new juror, Mr. Seaman?
Yes, just briefly, thank you. Mr. Seaman, how are you doing today?
Good.
Good, awesome. So did any of the questions that I asked, anything strike up? Anything inside you make you feel a certain way? No? Okay, so you understand then that Mr. Brown sits here and he's innocent until proven guilty beyond a reasonable doubt by the people of Michigan, correct? Okay, so would you have to hear from him at all in order to reach a verdict?
Based on what I've heard today, it's the prosecution's job to prove that, not so much the defense.
Okay, and do you feel that that's fair?
Yes.
And so when I was talking about, I guess, different types of witnesses, like police officers versus other types of witnesses, would you tend to believe a police officer more than another witness just because they were a police officer?
No.
Anything, understanding that you heard what the charge was, any feelings regarding that? Anything that you feel like in your history would prevent you from being fair and impartial?
No. I do not have any children's names.
Sure. All right, thanks, Mr. Seaman.
Peremptory challenges from the people.
None of this time, Your Honor.
Peremptory challenges from the defense.
Yes, Your Honor, the defense would like to thank and excuse juror number 1, Ms. Darling.
Right, Ms. Darling, thank you for your appearance today. Because we have to, everybody has to move for you now. And we will replace juror number 1 with Martha Tovar. course, making this as difficult as possible.
Want to scoot down, everybody go
Uh,
down one.
Let's see if she can make it, and then. Right. Ms. Tovar, you were able to hear all the questions asked?
From you and the young lady. yes.
All right. Mr. Wissy may have some follow-up questions concerning the people in this case. All right. Mr. Wissy, any questions of Ms. Tovar?
Yes, Your Honor. Ms. Tovar, you said from the honor and the young lady, you can't hear me too good, is that true? So were you able to hear me at all or get the gist of the questions from there?
I can hear you looking at me. Yeah, I can hear you
Okay.
from over there.
From there, and you do have some hearing issues. You brought that up, I believe, really.
Sometimes my ears just muffle up and I have no control over that.
Okay.
Ms. Tovar, after this after this voir dire process, do you believe it would be better if you sat and in Ms. McKinnon's, you'd be able to hear better?
I think it's the same for me. I can hear you both very well from wherever.
All right. You just let us know, okay?
Yes.
All right. Go ahead, Mr. Wissy. I'm sorry.
I guess just that when you have those hearing issues, there is going to be a video shown here today. You watch TV at home, I would assume.
I do.
If your TV was there, would you be able to hear it clearly?
High volume, yes.
High volume. Yes, I have no further questions, Your Honor.
Ms. Robinson?
Hi, Ms. Tovar, how you doing? Good. All right, so I know that you said that sometimes you do have trouble hearing some things. So you were able to hear me and you were able to hear the judge, but you weren't able to hear any questions asked by Mr. Wissy earlier, is that correct?
Unfortunately, yes.
Okay. Do you feel comfortable speaking up in a situation where maybe there's a witness on the stand and you didn't hear them? Would you feel comfortable letting the court know that you didn't hear that?
I would.
Okay. And do you feel like, you know, having sort of needing, I guess, higher volume or things repeated, do you feel like that would be a burden, or would it make you feel any sort of way that would cause you to maybe feel like you wouldn't be comfortable on the jury?
I would feel uncomfortable, but I would see the importance of knowing what was being said for the benefit of the person that you tried. Yes.
Okay, so it would make you feel a little bit uncomfortable, but you would do it anyways? Yes. Sounds good. Now, for the questions that I made to the group, you heard all of those, correct?
Pretty much, yes.
Okay. Did any of my questions strike you one way or the other? Anything stand out to you in particular?
No, not really. I understand what you're saying.
Okay. And anything where you feel like you would want me to know about any of the topics that we talked about? Okay. And I don't want to put you on the spot regarding any sort of hearing issues that you may have, but do you feel like you could be fair and impartial even with those issues that come up?
Personally, I feel that I would be fair, but I don't know what the court might accept as partially handicapped.
Sure. I don't have any other questions. Thank you.
Challenges for cause from the people?
None for cause, Your Honor.
Challenges for cause from the defense?
None, Your Honor.
Preemptory challenges from the people?
Yes, Your Honor, I'd like to thank and excuse juror number 1, Ms. Tovar.
Okay, so Ms. Tovar, thank you for your appearance today. We'll place juror number 1 with Titus Arena. Mr. Arena, I'll have you sit exactly where Ms. Tovar was sitting. And Mr. Wisty, any questions of the new juror, Mr. Arena?
Yes, Your Honor. Good afternoon, sir. And have you been sitting here, and were you able to hear all the questions so far? And do you have an idea, I guess, from what you've heard, what do you think of the concept of reasonable doubt means?
Mr. Arena, I'm gonna have you speak up as loudly as you can, okay?
I think you have to prove the beyond reasonable doubt that you know that.
So I just want you, it's not no doubt, it's a reasonable doubt. So you're permitted to use your common sense and reason. It's not, it doesn't have, it's not 100% absolutely no doubt. It's a reasonable doubt. The judge will give you jury instruction on that. You understand that concept?
Yes.
I guess, we had talked about a child abuse case. Does any particular feelings come to mind when you hear that charge?
No.
Do you have children of your own?
Yes.
What are their ages?
I have one daughter. She's 2.
Think it's ever appropriate to leave her home alone? No. And what are some reasons for that?
She runs around the house, so I don't think it would be safe to leave her alone. You know,
Yeah, I'm gonna have you speak up, sir.
I'm saying she's a very active kid and she runs around the house, so I don't think it's safe to leave her alone by herself.
All right, thank you.
Would there be any period of time you feel it's okay to leave by yourself?
When she's old enough.
When she's old enough?
Yeah.
But no time frame, you wouldn't leave her alone for X amount of time, I understand what you're saying.
Yes, no, no.
No further questions, Your Honor.
Ms. Robinson, any questions of the new juror?
Yes, just briefly. Mr. Orina, did I say that correctly? Orina, okay. If I mispronounced your name, you feel free to correct me, okay? Did you understand all the questions that I was asking earlier?
Yes.
Okay. Anything stick out to you in particular?
No.
Okay. Would you need to hear from Mr. Brown at all in order to reach a decision in this case?
Not necessary.
Okay. So understanding and knowing that you have a 2-year-old of your own, would that impact your decision in any way in this case?
No.
Okay. So you think you can be fair and impartial?
Yes.
That's all I've got. Thank you.
All right, thank you, counsel. Challenges for cause, Mr. Wisty?
None for cause, Your Honor.
Challenges for cause, Ms. Robinson?
None, Your Honor. Thank you.
And preemptory challenges, Mr. Wisty?
I would like to thank and excuse juror number 1, Titus Arena.
All right, Mr. Arena, thank you for your appearance today. You're excused. We'll replace Mr. Arena with Heather Whitson. Ms. Whitson, I'm gonna have you call over everybody to seat number 1, okay? Ms. Whitson, you had the opportunity to hear all the questions asked by Mr. Whitsey and Ms. Robinson? All right. And do you have any comments or anything special you'd like them to hear before they ask you some questions?
No.
Nothing in regards to those questions that you've already heard?
No.
All right. Mr. Whitsey, questions of Ms. Whitson?
Thank you, Your Honor. Good afternoon, Ms. Whitson. Looks like you're in the hot seat. So just briefly, you understand the concept of reasonable doubt?
Yeah.
Any questions about that?
No.
You understand it's reasonable, you're to use your, that's the purpose of jury, is to use their common sense.
Yeah.
Do you have any particular biases against police officers?
No.
Any particular, do you think you can be fair and partial on this child butt case?
Yeah.
But I guess anything that came up here, any thoughts or things that came to mind, you've been sitting there for a while.
No.
No further questions, Your Honor.
Ms. Robinson?
Yeah, just briefly. Ms. Whitson, I can finally say good afternoon now. How are you?
Good.
Good. All right. I know it's probably been asked and answered a gazillion times, but you understand fully that the state has the burden of proof in this case?
Yes.
Okay, so if you didn't hear from Mr. Brown in this case, but you still had some reasonable doubts, what would your verdict be?
Not guilty.
Okay, and do you feel comfortable with that?
Yes.
And understanding what what I talked about earlier with police officers versus other types of witnesses, would you hold what a police officer says any differently or any sort of way just because they were a police officer? Not,
No.
no? Okay. So you can follow the law in this case is what you're telling us?
Yes.
Okay, great. Nothing further.
Ms. Wissy, challenges for cause?
None for cause, Your
Ms.
Honor.
Robinson?
None for cause, thank you.
Preemptory challenges, Mr. Wissy?
None, Your Honor.
So the people are satisfied with this
People are
panel?
satisfied with-
Ms. Robinson?
One moment, Your Honor. Your Honor, the defense accepts the panel subject to all previous motions and objections.
All right, so the defense is satisfied with the panel. I'm going to release the rest of the jury, voir dire, panel voir dire. Thank you for your appearance today, and then I'll continue with the 7 that we've selected, all right? And for our game plan is I'm gonna read you the instructions and swear you in, and then we'll probably take it about an hour for lunch for the court to do some other matters. So you still got like 4 or 5 cases to move, and then you'll come back and we'll start with opening statements, but I'm gonna read you some instructions, all right? All right. Share my screen. It's all written on the. It's all written down. Share my screen. All right. Beauty of technology. So ladies and gentlemen of the jury, you have been selected to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly, to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. I'm gonna have you raise your right hand. Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. Thank you. You may be seated. Now I'll explain some of the legal principles you will need to know and the procedure we will follow in this trial. The trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his, or she may defer and wait until later to make her opening statement. These statements are not evidence. They're only meant to help you understand how each side views the case. To prove the charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with child abuse in the 4th degree. There is a minor child involved. And the question is that the questions you'll be asked to prove beyond a reasonable doubt is, did LaShawn Brown had care or custody of or authority over a minor child? That the defendant knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm or injury to a minor child. Actual injury is not necessary. And that the minor child was at the time under age of 18 as required by law. Next, the prosecutor will present this evidence in support of beyond a reasonable doubt of those elements. The prosecutor may call witnesses to testify, may show you exhibits like document or objects. The defendant's lawyer has the right to cross-examine all of the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has a right to cross-examine the witnesses. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all evidence has been presented, the prosecutor and the defendant lawyer will make their closing arguments. Like the opening statements, they are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence presented. You'll have a written copy of the instructions I'm going to read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for use during deliberations. My responsibilities as a judge in this trial are to make sure the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of the evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into the evidence, and anything else I tell you to consider as evidence. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the race, gender, or national origin of a witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court officer, who will give it to me. Do not show your question to the other jurors. If your question is not asked, it's because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the evidence might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. On the other hand, if you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to some of these interruptions. You must discuss this case. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not decide the case with anyone. You must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a jury, you're not allowed to discuss the case. If her or she continues, leave and report the incident to me as soon as you return, and that should be him or her. You must not talk to the defendant, the lawyer, or the witnesses about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case in court when you are acting as the jury and when the defendant, the lawyers, and I are all in here. The restrictions I'm about to describe are meant to ensure the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Now that many jurors have easy access to information through handheld devices and other technology, jurors may be tempted to use these devices to learn more about some aspect of the case. But if a juror were to do this, it would harm the parties. The parties' attorneys would have no way of knowing that a juror has gotten inside information, and that would have no chance to object if that information was false, untrustworthy, or irrelevant. Remember, no matter how careful and conscientious news reporters, family members, and friends, and other people outside the courtroom may be, information about the case from television, radio, the internet, social media will inevitably be incomplete and could be incorrect. Please bear these things in mind as I read the following instructions. These restrictions apply from this moment until I discharge you from jury service. You must decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that during the trial, you must not read, watch, or listen to news reports about the case, whether in newspapers, on television, on the radio, or the internet. You must also not research any aspect of the case during the trial. This means researching using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, computer, cellular phones, or other electronic devices. You must not visit the scene of any event at issue in the trial. If it is necessary for you to view or visit the scene, the court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. Before your deliberations, you must not discuss this case with anyone, even your fellow jurors. After you begin deliberations, you should discuss the case with your fellow jurors, but you still must not discuss the case with anyone else until I discharge you from jury service. Until I have discharged you from jury service, you must not share any information by any case as the previously discussed social media. If you discover that a juror has violated my instructions, please report it to my court officer. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room, decide your verdict, you must use your notes to help you remember what happened in the courtroom. Because information obtained outside the courtroom does not have these safeguards, it could give you the incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. If you do take notes, do not let anyone except the other jurors see them during deliberations. You must leave them in the courtroom during any breaks or lunch. Your notes will not be examined by anyone, and when your jury service is concluded, your notes will be collected and destroyed. You can see we've chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots to decide which one of you will be dismissed to form a jury of 6. So we will proceed with a jury of 6. One of you will be dismissed after the evidence is taken. The question the lawyers ask the witnesses are not evidence, only the answers are evidence. You should not think that something is true just because one of the lawyers asks the questions that assume or suggest that it is. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it and it must reflect the individual decision of each juror. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of other jurors who may have different backgrounds and perspectives from yours. All right, so those are the instructions, and you've been sworn in. It's 12:30. I think a reasonable lunch would be over an hour to have lunch. So we'll expect you back by about, I would say, 1:45 in order to restart. Then both sides will give opening statements, and then they'll present the evidence. Do you have any questions at this time?
Come right back here.
Come right back here to the 6th floor. Isn't that right, Nathaniel? Yep. Yeah, and look for Nathaniel. He's the guy to look for, all right? All right, so any questions or any comments concerning the instructions to the court, Mr. Wisty?
None, Your Honor.
Anything, Ms. Robinson?
No, Your Honor.
All right, we will see you back here at 1:45, all right?
Did we already did swear them?
Yeah, they're sworn in, yes.
Just
Sworn in twice now, so they might be tired of being sworn in. All right, so you can leave and come back at 1:45. There's a eating center on the 1st floor. In Washington, there's plenty of eating establishments. All right. Yeah, 1 second. It's just, you can just show it to security. All right, we'll use this time out of the presence of the jury. We did discuss certain matters off the record, and we can indicate that we were in agreement, Mr. Wisty, in regards to, or you asked for a ruling from the court concerning some of the videotape that plans to be a part of the prosecutor's case. And I found that a part 1 of the video concerning a witness who was not here would be in violation of the confrontation clause. So that video was struck. That was my understanding?
That is my understanding, and that would be from approximately portions 18:0. Approximately 11:42 of the video to 18:03.
All right, that's your understanding, Ms. Robinson?
It is, Your Honor.
Okay. The second aspect is there's a brief statement made during a conversation that I will advise the jury is whether they hear it or not is really, there's some question as to relevance, but the editing it out would be problematic. I will indicate to the court that I'm not I'm instructing them not to use that as substantive evidence. Is that your understanding, Mr. Wisty?
Yes, Your Honor.
Yeah, Ms. Robinson?
It is, Your Honor. Thank you.
And then we had some questions about using the minor's name. It did appear on one of the slides, just because we missed it, because it was not a part of the elements to be proven. But I'll make sure it's not on the third slide. Anything else from the people?
No, Your Honor.
Anything, Ms. Robinson?
And I wanted, we also did talk about I think portions at the beginning where some of the officers are asking, I guess, the child some questions.
Correct.
And kind of like implying a response. The people have agreed that they aren't going to say that those responses came from the child themselves, which is fine. So I think we're all set on.
All right, and anything substantive matter would be subject to cross-examination. And then the jurors, of course, are left to their own devices, but they'll know that the questions themselves are not evidence. Anything else, Mr. Wisty, in regards to instructions or the plan that we have this afternoon?
No, Your Honor.
Ms. Robinson?
And then I would just like to briefly put on the record the cause challenges for the jury selection.
Yes.
The defense did make a cause challenge that was agreed upon for juror number 6 at the time, which was a Mr. James Lee. We did have some questions about whether he fully understood the English language. That was agreed upon and granted by the court. Second, the defense did make a cause objection for juror number 1 at the time, a Jody Darling, where she stated that she would believe a police officer over another type of witness. The court did follow up with some questions regarding that, and that cause challenge was denied.
Noted. Yep. That's anything else, Mr. Wisty?
No, Your Honor.
All right. So we've put on the record the challenges and the preemptory challenges and the challenges for cause that were previously discussed. I'm not sure you have time for lunch, but we're going to be back here, I think, about 1:30 to try to see, or 1 o'clock. Yeah, to see if we can. Yeah. So we'll see everybody back here at 1 o'clock, and then we'll go back on the record.
Thank you.
Thank you.
1:45 is when we're back.
What's that?
Trial itself, just, I need to tell my officer.
Sure. Yeah.
He left.
Left. Did he have some indication? Do you know what he was-
We know your office knows there's a trial, right?
Told him 1:45, he said, okay.
Okay, not the office.
You can go do whatever you want to do.
Oh, they're talking about the police
By
officer.
1:30, okay? So
My
no
officer.
later than
They
1:30.
sent me here. today.
Yeah.
Wendy, I have
Honestly,
a
if you
question.
see a juror
I think
or
I'm
anything on the
David
street, like,
Cheney.
just ignore, walk away, that sort of type
I
of
don't know,
thing.
can I bug you in a
Otherwise,
second? I gotta check.
Thank you.
I remember I had a question for you.
I brought
I don't remember what the question was.
Yeah.
I'm
That's a
guessing-
competency, right?
I'm guessing you're wondering where the other case is and if you've been found competent or incompetent on it. That's one of
Who's his attorney?
All right, man. Thank you, man.
Oh, we're on the record in the docket 22-00292. People of the state of Michigan versus Santana Lira. And sir, you are Santana Lira?
Yes, sir.
All right. This time set for a probation violation arraignment. And so I'm going to indicate to you what the charges that have brought against you. They're just allegations. And then we'll go from there. So it's an indication today that this is from a probation violation brought by Brendan Hanna on November 17, 2022, was signed by myself on November 21st, 2022. The request and summons for probation violation indicates that you violated your terms of probation by failing to report to a probation officer on October 19th, 2022 and November 16th of 2022, that you failed to submit to random drug testing on October 3rd, 2022 and October 18th, 2022, and that you failed to provide verification of a 12-step meeting attendance. Those are the allegations that have been brought against you. You have a right to a hearing contesting these allegations within 14 days of today's date, Mr. Lira. Do you intend to seek counsel for that hearing in order to represent you in regards to these probation violation allegations?
Yes, Your Honor.
All right, and are you going to seek representation from the public defender's office?
Yes.
All right. The onus is upon you to contact the public defender's office in regards to representation. Do you have their number, sir?
I believe so, yes.
All right, and if you have the number, they're also, but that number you'd call, you'd tell them what date we're setting this for hearing in order for representation. We're going to set it 2 weeks out, so it'll be within 14 days. So I'm going to indicate for the file that you plan to be represented by the public defender's office at hearing. Excuse me. And that hearing date is
December 15th at 1:30.
okay, December 15th at 1:30. My understanding is you're going to seek your representation from the public defender's office. Make sure and give them that date, that December 15th, as the date that you'll need representation. All right, sir?
Okay. Yes, Your Honor.
All right. All right. So we'll see you back here at December 15th at 1:30. All right, Mr. Lira?
All right. Yes, Your Honor.
All right. You're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
last name Mukoma.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm that you'll make a true and understandable interpretation to the witness and that you will accurately interpret the statements made by the witness or the defendant to the best of your ability?
Yes, Your Honor.
All right, thank you. So I'll call to the record docket 22-01507. That is the people of the state of Michigan versus Noel Jackson.
Sema ametana hiyo namba, kesi namba yako kwamba ni 220127 kwamba ni makumbana na state of Michigan na Jackson.
Will the parties please introduce themselves for the record?
Walikuja waseme wao wenyewe majina lao.
Big West on behalf of the people.
Jack West yeye anashughulikia watu wa serikali.
Lauren Sutter, I'll be appearing today for the defense today.
Flores na yeye ni mwenye anakushughulikia wewe mwanasheria yako.
And in this file 057 indicate, I'm going to indicate for the record what the defendant's being arraigned on.
Nasema kwamba yani hii file sahihi alisema yani 057 kwamba ni nitamwambia kwamba mwenye aliharibu yale alifanya.
So the allegations have been made
Kwamba ni tatizo alitokea
that there was a request for probation violation submitted by Mario Ledesma on November 16, 2022.
kwamba yani kulikuwa na habari kutoka kwa Mario Ledesma kwamba yani wewe umevunja sheria ya probation kwamba mwezi huu tarehe 16.
And it was signed by myself on November 21st, 2022.
Mimi umenikuta kwamba ana makaratasi mwezi huu tarehe 21 mwaka huu.
The request and summons for probation violation indicates that you violated your probation in the following manner.
Anasema kwamba yani haya ndio umevunja kwa hiyo sheria ya hiyo probation.
You failed to report to your probation officer on September 9th, 2022 at 10.
Ulishindwa kuenda kwa probation officer yako mwezi wa 9 tarehe 9 saa mwaka huu saa 4 kamili.
And at 10:30 a.m. and that appointment was confirmed in the office with the client present on August 29th, 2022.
Kwamba ni ulikuwa kwa ofisi hiyo tarehe kwamba ni na uliconfirm hiyo ka anlandevu kwamba ni mwezi wa 9 tarehe 29.
You also you violated your probation. The allegation is by failing to pay fines and costs in the amount of $690.
Nasema pia ulishindwa kulipa franga kwa sababu hiyo nayo ilikuwa kwa hiyo probation kwamba ni 690
as of October 27, 2022.
Toka mwezi wa 8 tarehe 27.
For the total amount of $1,977.96.
Sasa yote yalikuja kwamba 1960.
You of course can be represented by a lawyer in regards to the hearing on these probation violations.
Kwa kusikia haya tunaweza leta mwanasheria kwamba ni asikie.
Do you plan to seek counsel to represent you in contesting these charges?
Kwamba ni unataka utafute mwanasheria ukuje ugombane na hii hapa wamekuambia? No.
How do you because of today's schedule, we're going to set this for hearing.
Leo kwamba ni kwa vile yani tulisema kwa hii habari tutapeleka kwamba yani tusikize kila mtu yani.
Okay, and you'll have up until that hearing date to seek counsel if you choose.
Kwamba yani na pia kwamba yani unaweza pata kama unapenda kuchagua mtu wewe mwenyewe kuja kusemea unaweza chagua.
If I remember, were you represented previously on this file?
Yes, I was.
He was? Yeah, I'm asking you to translate if he was.
Anauliza kwamba ndio ulikuja kwa hizi habari hizi hapa zinaongelewa, si ndio? Ndio. Yes.
And you know that you could face incarceration concerning this file if it's found that you violated your probation.
Sema kwamba unajua kwamba nikipatikana kwamba umeharibu unaweza fungwa kwa hii habari yao.
Do you understand that, sir?
Naelewa hiyo. Yes.
All right. I'm going to set it for a probation violation hearing.
Ndio kwamba ni kwanza nitakutuma huko probation kwamba ni tuyasikie habari zake.
December 15th at 1:30.
Yani mwezi wa 12 tarehe 15 saa 7:30.
And I think Ms. Sutter is representing you on the final pretrial date, is that correct?
Sema kwamba Misava naye labda anakusimamia kwa habari nyingine ya mwisho leo.
That's correct.
Okay,
Hiyo ndio kweli.
and I'm sure she would answer any questions that you might have concerning representation in a formal hearing on this charge, on the probation
Sema kwamba
violation.
na hakika kwamba ni yeye swali yoyote uko nayo anaweza kukujibia.
You understand that? All right. So we'll set it for formal hearing on the probation violation on December 15th at 1:30.
Anasema kwamba tutakuja kusikiana uso kwa uso kwamba hapa mwezi wa 12 tarehe 15.
And that's live in person.
Tunakuja hapa ndani.
Okay, that's all for the record in docket 22011507.
Kwamba hiyo ndio docket yake, hiyo ni moja imeisha sahihi.
And now I'm going to call to the record docket 22022657.
Kwamba atamaliza hiyo kwamba ni 22 kwamba ni 01 alafu 27 hiyo nyingine.
Will the parties please introduce themselves for the record?
Kwamba ni watu wako hapa waseme kwamba ni kwa hii habari.
Jake Westy on behalf of the people.
Anasema Jake Westy yeye ni mtu anashughulikia na watu.
Assistant Public Defender Lauren Sutter on behalf of the defendant.
Huyu ni mwanasheria kwamba na yeye anasimamia wewe.
And sir, you are Noel Jackson.
Na wewe unaitwa Noel Jackson. Yes.
Okay, thank you. This is the time set for a final pretrial in the matter. Mr. Wisty, how are we proceeding?
Ndio, leo ni mwisho wa kusema haya maneno ya kuzungumza. Mr. Wilson, nataka utuambie nini?
The people have been unable to get their witness here this afternoon.
Ya, watu wa sheria walishindwa kuleta wenye mashahidi kwa hii habari kwa leo.
And as a result, we'll be filing a dismissal that will be without prejudice.
Anasema kwamba yani itatokea kwamba hiyo kesi inaisha lakini itakuja kurudiwa.
And that's your understanding, Ms. Sutter?
It is, we have no objection.
Ndio kwamba anaulizwa mwanasheria yako hayo ni umeelewa, anasema ndio na hayo anasemeka.
All right, so Mr. Jackson, the people are moving to dismiss this case without prejudice.
Watu wa sheria kwamba mahakamani wanatoa hii kesi bila
because of the victims failed to appear today.
Sababu mwenye kuumizwa hajakuja hapa.
This case may be brought with additional evidence on a later date, but for our purposes today, the case is dismissed.
Anasema kwa leo imeisha hivi, lakini akikuja mwenye kuumizwa akisema ndio kesi yangu nataka iende, atakuwa anapeleka naye.
Anything else to the record, docket 22022657?
Nyingine yoyote tunaweza sema kwa record hapa. Anasema wacha nikaribia hapo kwa judge.
Thank you, Mr. Wisty, and I'll sign the nollie pros. Anything else, Ms. Sutter?
No, Your Honor.
That's all for the record in docket 22022657. We'll see you back here on your probation violation, okay?
Thank you.
Thank you, sir. And then you're here on the Karangwa matter also.
Huh? Nyarwanda?
What's that? Yeah, I think they were trying to get you here on both matters as an interpreter. We have another, but I'm not sure how that happened. I'm not sure. All right. So make sure you get paid for both of them.
He's not here for both.
Okay, he's not? Okay, he's only here for the Jackson matter.
Yes.
Do we have an interpreter for the?
Yes.
Okay, we do. All right, a different interpreter, I think, right?
Yes.
All right. All right, so, and that interpreter can leave. You can leave, sir. You're all set.
Nathaniel, would you mind getting a copy of the nollie for him?
Yeah, that's fine.
Thank you.
Yep.
Okay.
So, Ms. Sutter, do you have Mr. Harimana?
That's
my
Ms. Robinson.
Okay.
Your Honor.
Interpreter?
Yes.
The interpreter's here,
Oh, that's you. Okay, I'm sorry.
but he's in custody, right?
Yes.
All right.
Is he gonna be brought up?
Yeah, I'll get it.
Okay.
All right.
Yeah, no rush, whenever you're ready.
Yeah, and then, because Mr. Wilhart's on the mobile cart. We're waiting for Mr. Abbott.
Mr. Wilhart's here. That is,
Oh,
I'm blanking on his name.
that's
but-
Mr. Cheney.
Yes.
Okay. So are you ready on Mr. Wilhart?
Yes, Your Honor.
And Do we need Mr. Ledesma for that?
No, Your Honor.
Okay.
I think I briefly mentioned this off the record. I can't see any indication Mr.
Right,
Wilhart has previously
you did.
applied.
You
Yeah.
did. All right, so let's bring Mr. Wilhart up.
Sorry, Your Honor.
No, that's fine. Um, Make a note in here. So we're on the record in docket 21-02793, people of the state of Michigan versus Cecil Wilhart. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Lauren Sutter. I am not the attorney of record for Mr. Wilhart, but I would like to make a request on his behalf today.
Okay, and you, sir, you are Cecil Wilhart? All right. It's my understanding that this is the time set for a probation violation hearing, and that we're also right in the middle of a jury trial. Mr. Wilhart, it's your intention to seek representation from the public defender's office in this case. Is that what you're going to speak to, Ms. Sutter?
Yes.
Okay, go ahead.
Thank you. I briefly spoke with Mr. Wilhart before this, asked him if he'd applied. He'd indicated that he may have called our office and they gave him some not quite helpful instructions, it sounds like. So he's unrepresented today. I don't think that's his desire. I would request an adjournment on his behalf today so that I can personally complete the application with him and we can get him on a more concrete path moving forward.
All right, Ms. Wisty, any objection to that? I mean, it's not a bad day for an adjournment, given the circumstances that we're right in the middle of a jury trial.
No objection.
All right, so Mr. Wilhart, we're going to adjourn this matter so you can seek representation from the public defender's office. Ms. Sutter can walk you through that process, okay? I'll get a new date for the probation violation hearing, okay? New date for hearing?
December 15th at 1:30.
December 15th at 1:30. So you have the right to be represented, of course, at that hearing. Ms. Sutter will walk you through that process. She has that date. And we'll see you back here on December 15th at 1:30. Okay, sir?
Sir.
Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, thank you for your help today.
Thank you.
We're not done by February. They can come back, right?
Well, we could just send them. This is a new system, so I don't know. I would say,
I mean, if we're not done by 4:30, we're not done by 4:30.
I would say if possible, and it doesn't look like we're gonna be done by 4:30, try to call recess around 4-ish. And Nathaniel, take them downstairs and get the money, bring them back up.
What if they're here till like 9?
It's still a day. The only thing that would be different.
We're not gonna stay here till 9, Judge.
Is if we rescheduled it. The only thing is if we continued it, that would be the thing.
I was just trying to think of, I mean, I've had juries
How
out
far
to,
we are now.
Yeah,
I put down to
and-
that.
I've had juries out come back like at 9:30. Just seems like you pay for more than just a full day if they work 12 hours.
Well, it would seem, but
I would guess, but
What is the payment?
33?
When was the last time that was updated?
That's a great question. That's been 33 as long as I can remember. The only thing. So we're on the record in docket 22022320, people of the state of Michigan versus David Cheney. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
Good afternoon, Your Honor. John Abbott representing David Cheney. He appears on video today.
Sir, you are David Cheney?
Yes, sir.
Okay, you can hear me all right, Mr. Cheney?
Yes, sir, I can.
All right, Mr. Wisty, this is the time set for a forensic review. And I do have a report that was labeled, that is dated November 18, 2022 in regards to competence to stand trial. How are we proceeding today?
Your Honor, the people would be stipulating the entry of the report. I believe the defense will as well. It's going to find it competent, and I would request this be sent for further proceedings at the court's discretion.
Is that your understanding, Mr. Abbott?
Mostly.
Okay, mostly.
I have no objection to the entry of the order, Your Honor. I have no basis for objecting
Right.
to this entry into evidence. I can't agree with their conclusions, however. I mean, if you read the report itself, it establishes, rather than establishing that he is competent, it gives us plenty of reasons why he isn't competent. You know, starting with an IQ of 69, special ed all through school, repeated hospitalizations in mental health facilities on 7 prior occasions. He shot himself in the head in 2021 and then lied about it. So some suicidal tendencies. A description of his behavior includes head banging, for example, where, you know, just to get the demons in his, the voices in his head to quiet down, he bangs his head against the whatever hard surfaces are available. And the recommendation from the author of the report is that we just be patient with him and take some extra time to explain to him what's going on. And, you know, can you imagine, you know, if we're doing a preliminary exam or a trial in front of a jury and he's hearing voices and he needs some time to bang his head against the table? Are we gonna, you know, that's not okay. And furthermore, not just the head banging, but the fact that he hears these voices and they tell him to do things that are wrong, self-harm, hurting others. You know, he's constantly hearing voices. It also indicates in the report that he has great difficulty understanding or interpreting what people say. And that's one of the basic things that people need to do in order to help themselves or help their attorney at trial, is to listen to testimony and appropriately interpret the statements that are made on the stand and by the witnesses. And if he's constantly misperceiving people's intentions and misperceiving their ideas, that seems hardly the same. Now, that doesn't make him competent to stand trial. He can't help me out if he can't understand or if he can't correctly perceive what people are saying or attributes to them motives other than, you know, rational motives, for speaking. He's described as hearing ego dystonic voices telling to hurt himself, and that they say dangerous things as well, telling him that the people that are talking are not telling the truth. So the voices in his head are telling him that the people that are talking are not telling the truth. He sees people coming out of the ground. He sees himself in a world that he's not even in. Sometimes you feel like he's living in a game. When the author of the report discussed the roles of the various parties in the tribunal here, he's persistent in stating that the judge would be against him. That's on page 8, third paragraph. Persistent in stating the judge will be against him, and initially indicating that the prosecutor was on his side, and only after some apparently what the author recalled was educating him, he was able to get him to change the answer to that question. I don't know that I'm convinced he actually changed his belief in whether or not the prosecutor was on the side. And then he, for example, he stated that he believed his attorney had tried to explain the relevant information, but Mr. Cheney had stopped listening because he was upset. Similarly, if we have this kind of thing going on in the courtroom, Your Honor, and something upsets him because he's misperceived what somebody said, and I'm trying to explain to him what's going on, and he decides he's going to stop listening, he's not competent to stand trial, Your Honor. And as well, he said he could not recall what his attorney had said because he was overwhelmed by anxiety and paranoia during the contact. And he also, at the bottom of that paragraph on page 9, he indicated he was unsure how he could assist his attorney in his own defense. So I guess when I read this report, I was surprised to read the conclusion reached by the author in that she said, oh yeah, he's fine for trial, just have to be extra patient with him and take some extra time to explain things to him. Where clearly people have been taking extra time explaining things to him since he was in 4th grade. And, you know, here we are today with these criminal behaviors. I don't think he's competent to stand trial, Your Honor.
All right.
So, but certainly it's up to you to make that decision.
Well, I do read the report as indicating that the report has indicated a past behavior that certainly causes one pause. The report writer does indicate at the end of that is past behavior, and their current determination is that the defendant be considered competent to stand trial concerning the current situation of the defendant. I would agree that some of the past certainly gives pause concerning some of these, and the past is fairly recent, but I have to take the professional at their word that based on her determination that the defendant is presently considered competent to stand trial. So I'll accept the report as is, indicating the defendant is competent to stand trial, and I will sign an order to that effect. That we still have the other issues concerning criminal responsibility, and we also have outstanding files that still have to be determined. And so I'm reluctant to name a docket date for this matter, not knowing when, but what would be the next date? It would be on this file, but we still have a criminal responsibility portion of this out.
That is my understanding.
That's, you know.
Your Honor, based on my communication with the Forensic Center, they can't give me a solid date. I have several of my clients that are being evaluated for criminal responsibility, and they are overwhelmed with these cases.
Right. My understanding is the real question is, has he been seen for criminal responsibility, or we're just waiting on a report, or are we waiting for an interview? Because the two seem to be at odds with each other. Waiting for an interview still means that we're waiting for a report afterwards. Do we have any determination on that?
I have no indication.
All right.
of the
I don't know
status.
either.
All right.
Our next prelim day is December 15th at 8:30.
So let's set it for December 15th at 8:30. And then we'll go from there. So December 18th, December 15th at 8:30. I don't think we can go forward with a criminal responsibility with a preliminary examination without a criminal responsibility, at least for you to consider as part of the process.
Thank you, Your Honor. I agree. I'll take some time and try to find out from the Forensic Center what's the status on that.
All right. All right.
On that question.
All right. So this is set for prelim on December 15th at 8:30. Anything else for the record, Mr. Wisty, on docket 2202-320?
No, Your Honor.
Anything, Mr. Abbott?
Well, thank you.
Okay, thank you, Mr. Abbott. I'll sign the order on competency, and then we'll wait to see further actions.
You may approach.
You may. Yeah, that's probably the easiest way to do it. Okay. All right. and remind me, we're doing that on the 15th. Yeah. So we'll do accommodate a breakout room on the 15th, just because we haven't been able to set up
Playing phone table, yeah.
right. All right, so this is reset for December 15 at 8:30, and then we'll go and see where we're at that stage.
Okay.
Anything else, Mr. Wisty?
No, Your Honor.
All right, that's all for the record of this file. Thank you for your appearance today, Mr. Abbott. Call Mr. Briner, and then we can get the jury in. So we're on the record in docket 21-01725, people of the state of Michigan versus Andre Briner. This is the time set for a violation of probation hearing. Counsel, your appearance for the record.
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Briner.
This was set for 1:30. It's now 1:55. How are we proceeding today, Mr. Wisty?
Your Honor, the people would request a bench warrant.
Ms. Robinson, have you had any contact with Mr. Briner?
So I have not, however, somebody from my office has. He has another open felony case, and so he's been in contact with this felony attorney. I was kind of swamped last week, so I
Right.
did give him a call over the weekend, but have not heard back.
All right, this is a fail to appear for the probation violation. I don't have any, I have a previous fail to appear. So defendant is bench warrant and bond forfeiture at this time for fail to appear. Anything else for the record in docket 21-01725, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, that's all for the record in this file. And then we can bring in the jury and start our opening statements.
Mr. Brown just briefly went to the back. He stopped.
Okay, that's fine. Oh, Mr. Cheney, you're free to leave.
Your Honor.
All right. Thank you.
You're welcome.
doing an action that puts a child at an unreasonable risk of harm or physical injury. And that's an action that puts them at an unreasonable risk. We touched on this about for a year. It's not necessarily proven that the child was actually harmed, but that by the defendant's actions, he put him at risk of harm, and that was unreasonable to do so. What you're going to hear is testimony from Officer Tyler Stages, who came to investigate an incident back in September of last year on Pontiac Street here in Lansing. So what happened is Mr. Stias came to investigate a different matter not pertaining to the child. When he got there, he arrived at the defendant's home. He went up to the defendant's home and knocked on the door. Nobody answered for a period of time, and eventually who answered was a 3-year-old child. You're going to see video of this interaction. And what we can gather from the evidence you're going to see is that for at least a period of 10 minutes, from the time the officers arrived to the time somebody came to see the child, that child was home alone. And ladies and gentlemen, leaving a 3-year-old child home alone presents that child an unnecessary risk. From there, you're going to see that eventually, or you're going to hear testimony that eventually someone did come to get that child. And you're going to hear the defendant make some statements about where he is. You will see those statements on video. Whether or not he testifies will be a matter for the defense to address. But you will see his statements on video, ladies and gentlemen. And when you see those, I will touch more and discuss them after the evidence is presented. But those statements do not change the fact that he left that child home alone for 10 minutes and put the poor child at risk of harm for that period of time. I believe after the evidence is presented, you will find beyond a reasonable doubt that he is going to be charged with offense. Thank you, ladies and gentlemen.
Ms. Robinson, do you plan to do an opening statement?
I do, Your Honor.
All right,
Thank you.
you may proceed.
The people want you to believe that this case is cut and dry, that Mr. Brown left his child home alone at a time officers came there, nobody's answering the door, therefore he should be found guilty. But there's more to the story, and you're going to hear that there's more to the story. You're going to hear from the testimony that's presented today that Mr. Brown did have somebody there watching the child. That person may not have been at the door at the time the police officers arrived, but that person was there. They were there, and you're going to hear that. Those are the statements that the state just mentioned about it doesn't change the fact. But you're going to see from all the evidence presented that it does change the facts, because it is reasonable for someone to have somebody else, an adult of age, watch their minor child. So I just want you to listen throughout the trial, hear all the things of what the officer is going to be testifying to you about what they did. And I'm sure the state's going to bring that to light. But also listen for the things that they didn't do, or perhaps the things that they missed. That can be important as well. So thank you all for being here today. I just ask that you remain open, listen to everything. Thanks.
Are the people ready to call their first witness?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. I will be calling Officer Tyler Stages, and if I may be briefly excused.
You may.
I'm sorry, Judge, I would just invoke the rule, but I know that,
Sequestration?
yeah, but I think there's only one witness, so.
Right, I don't think there's any, I think there's only one witness, and if that changes, let me know and we'll
Thank you.
invoke any sequestration order. But I know everybody in the room right now, and none of them are testifying, so. Officer Stelgis, I have you come up here. Please state your name and spell your last name for the record.
Tyler Stelgis, Stelljes.
Officer, you solemnly swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, please have a seat here. I'm going to ask you to project as loudly as you can for recording purposes. Mr. Wissy, you may proceed.
Thank you, Your Honor. Just one more time, could you state your name for the record?
Tyler Stelgis,
Where are you employed, sir?
Lansing Police Department,
What is your job title there?
police officer,
How long have you been in that position?
6 years.
Were you working on September 18th, 2021?
Yes,
And when you were working, did you come in contact with the defendant in this case?
yes,
And do you see him here today?
I do.
And could you point him out to the courtroom? Could you point him out and identify something he's wearing?
A green and red striped shirt.
The record reflects the witnesses to identify the defendant, Mr. Brown.
Any objection, Ms. Robinson?
No objection.
Without objection, the witnesses identified the defendant.
Where did you come in contact with Mr. Brown that day?
At his residence on Pontiac Street,
What city is that?
City of Lansing.
And what county?
Hang on.
What brought you to Pontiac Street that day?
Responding to a trouble subject call involving his neighbors.
About what time was that occurred? Do you recall?
I don't recall. It was the evening time.
When you responded to the troubled subject, what did you do after first arriving on the scene?
We spoke with the neighbors who were called for the incident.
And from there, where did you go?
I went to the defendant's house.
And when you got to the defendant's house, what did you do from there?
My partners and I were knocking at the door announcing that we were there, and we could hear a small child inside the house.
What happened from there?
He was unable to open up the front door for us. There was no adults there answering the door, coming from any of the windows. So we assumed that the child was by himself. So he was unable to open the front door. So I went to the back.
Wait, just back up a little bit. When you first arrived on the scene, was this home visible to you?
Yes,
And did you see anybody enter or leave the home?
No.
And so let's go forward then. At some point, you see the child inside the home?
yes.
What's going on there? What happens from that point?
My partners were speaking with the young child. He was saying that he can't get out. So we were doing the best.
Objection, Judge, hearsay, confrontation.
Response?
I believe that should be stricken there.
Okay, so we'd strike any comment concerning substantive comment as to what the child said.
Judge, can we approach briefly?
Sure.
Thank you.
So I can make it clear. So, yeah, so any indication of what the child said, and the child's age is we're gonna find out is of younger age, but that's not substantive evidence, all right? The questioning of the child, is not substantive evidence, what they said, that's hearsay, and we have a very young child. Just so you know that, okay? That just so you know, it can indicate something other than why the officer acted the way they did. But as far as the child's not here to testify, so we have a cross-examination issue concerning the child. Mr. Wissy, you may proceed.
Thank you, Your Honor. So let's go back. You're at the house. Tell us what you see. How do you see the child?
A female arrived at the scene and let the child out of the house.
About what time did that happen?
I don't know.
How long had you been on the scene?
It was about 5 to 10 minutes.
And after the female arrived on the scene, what did you do?
I spoke to her, tried to get as much information I could from her about the father and about the child to try and confirm to see if there was any supervision at the house.
And then at that point, the defendant eventually arrived on the scene.
Yes.
And how did that happen? What occurred there?
While we were speaking with the female, he showed up in a vehicle.
Did you have a conversation with him?
I did.
How did that conversation begin?
He had said that he had an issue with his neighbor and that he had left. He had told me that the child was left in the care of his aunt, and he described his aunt to me as a crackhead. We didn't see any female aunt on the scene.
Did he tell you anything about the child?
He said it was his son.
Did he give you an age or any indication like that?
He had difficulty giving me his birthday, but he was able to tell me he was about 3 or 4 years old.
And from viewing the, you actually saw the child, correct?
Yes.
And from viewing the child, did that seem an accurate statement of the child's age?
Yes.
And while we were at the house, did you hear anybody besides the child in the home?
No.
Did you hear any footsteps?
No.
Anybody say anything?
No.
Any movement?
No.
And when you're there, you can physically, you can see how can you see the child? Explain that to me.
I initially saw him. We had him come to the back of the house. There was an open window.
So are you looking into the house at this
Yes.
point? Did you see anybody else?
No.
What could you see inside the house from that angle?
There were bars on the window, security bars.
How far could you see a room inside the house? Anything along those lines?
No.
And then did you have your body cam on for this?
Yes.
Your Honor, at this point, I would like to show the video that's been previously marked as Plaintiff's Exhibit 1. I would play it and authenticate it and then move for its admission.
All right, then, you may proceed. If you're going to show the jury, you probably should move for the admission beforehand.
So I thought process, I'm going to show the video, ask him if this is indeed the video.
Okay, that'll work.
He can
Right,
confirm
so
it's
he
the
can,
video.
you can authenticate it as the video from his body cam.
Yes.
All right. I'll let Daniel turn up as loud as I can. When you're ready, Mr. Whiskey.
And then officer, do you recognize this screenshot for lack of a better word?
Yes.
What does that appear to be?
Me and my patrol vehicle.
And based on everything in here, you can see the axon body. What does that mean?
It's just the video from this incident.
So this would be from looking at this image, this would indicate this is your body cam video.
Yes.
At this point, I would move for the admission of People's Exhibit 1, Your Honor.
Any objection, Ms. Robinson?
No, Your Honor.
Without objection, People's Exhibit 1 is admitted into evidence. You may publish to the jury.
Thank you, Your Honor. So officer, I'm going to begin this video at the 5:54 mark. This would indicate, when do you start recording?
I started recording as I exited my vehicle.
So the 5:54 would be roughly 5 minutes and 54 seconds after you arrived on the street and exited the vehicle.
Yes.
And for that period of time, you would have had a view of the defendant's home.
Yes.
Attention, please.
Attention, please. Let's talk you real quick.
We're good.
And at that point in time, when there was a knock, did you hear anything coming from inside the house afterwards?
Not at that point.
Oh, answer please. Can we talk to you real quick?
Couple, hear any noise coming from inside the house?
No.
I am hearing voices on those, wherever it was coming from.
I believe it's a neighbor's.
You okay, buddy? Yeah, get the door open.
Adult or kid?
Kid trying to push the doorknob. See if everyone.
Is it unlocked?
I don't know. Are you okay, little buddy? Need help opening the door? You okay? Are you okay?
Start banging on
Mom and
windows.
Dad home with you?
Start banging on windows.
You want to get out?
Attention, please.
That portion, when you were at the door, were you able to see through that glass pane at all?
I don't remember.
Attention, police department. I want that kid to come right here. I can get the screen off. So right now, what's going on is the kid's in there, we think, by himself. The Paul guy or whatever left his kid. Can he talk and understand?
No, a little bit.
See, that back window's open. See if he can go back there to that fan. There's a back window that's wide open. Hey, right here, this window, right here. Jeez, dude. Go to the window over there. Hi, you by yourself? Go to the window. The window.
Hey, bud. Oh, boy. Is there anyone in there with you? Are you up? Daddy's gone. Are there bars on Daddy's windows? Because that's very confusing. Do you think you can open that door right there? Can you figure out how to open that door right there? There's no one else in there with you? No. No one else is home?
Go ahead.
Police department.
Oh, these are like window bars.
Police department.
See if you can you open that door, buddy, over here?
Then I'm hearing a female's voice there at that point in time. Can you tell us whose voice that was?
Drake Blackman.
And where was that coming from?
She was coming from the front of the house.
And what did she eventually do?
She was able to, she had a key to the house. She was able to open up the door, remove the child from the home.
And I had another question. Here we're looking at 11:33 is on the timer. Is that fair to say that represents 11 minutes and 33 seconds from the time you got there until this time right now?
Yes.
And again, you could see the house the whole time you were there, and nobody's going in and out.
Yes.
And then there were some other periods where you were knocking, yelling, police, things like that. Besides seeing the child, did you see any noises, anybody else you saw, anything other than the child that you heard a noise from inside that house?
No.
I'm gonna just play this shortly and then stop it and proceed to a different matter. And now we can see a woman in the bottom left corner of the video. Who is that?
Drake Blackman.
Where did she approach from?
The front of the residence, down the driveway.
Any reason to think she was in the home?
No.
How do you know that?
Because my sergeant and my other partner was at the front of the residence the whole time.
Good. Just may the record reflect, we had stopped the video at roughly 11:42. We are now proceeding at 18:04.
The record may so reflect.
Officer.
I'll tell you what's going on, okay? I know you.
Now, can you tell me who that is?
The defendant.
At this point, where did he come from?
I don't know.
So we saw the car had pulled up on the side.
Yes.
Okay, we're just here to solve that. We're trying to knock on your door, see what's going on. Okay, problem we have is your son. We can't be leaving a kid behind like that.
My auntie's in there. She was taking a shower. She went to the
No one's answering the door.
Yeah,
Your son's turning to the handle.
Yeah.
I need help.
No,
help,
the door's broken. So you have to go to the back door.
Okay, so there's an adult here right now.
Uh-huh.
Okay, can you go get that adult to verify that there's an adult here? So
she left. She's a crackhead, but I leave her here. So that's it.
Wait a minute.
So
Let's start over. Is the aunt here now?
she was in there when I left. So she got one. I told her to stay here while I was arguing with them because he verified he was going to call somebody on me. So I walked and got somebody too. So that's it.
I gotta get all your info. Okay.
Yeah.
Sean, can you spell that for me?
It's Brown.
SHAWN.
Yeah.
Brown.
Yeah.
You have a middle name, Mr. Brown.
D.
What is it?
Dontel.
Can you spell that for me?
DONTTAL.
TT.
I mean, I shouldn't even have to do all that because of verbal, but nobody fighting. I know my rights.
I'm clear on that. But
Yeah,
you
okay.
do have to do it for the child issue.
Yeah,
okay?
yeah, no,
I'm obligated to do two things. I'm obligated to contact CPS.
I know.
I have to.
Yeah,
So I have to
mean,
get your info, the kid's info.
I have custody of him because
Yeah, that's fine.
my auntie watches him. They watch him.
Dontel. Spell that for me.
DONTAAL.
TA.
Where's my other officer I know?
How many A's?
It's 2 A's.
DONTAAL.
Yep.
Okay. Sean, what is your birthday?
7/16/76.
And you live here.
Yeah, I own this house. They are my friends.
What's the phone number for you, Sean?
317-746-1689.
746-1689.
I was only gone 2 minutes.
What is your son's first name?
Alante.
Can you spell that for me?
Brown.
How do you spell Alante?
ALONTAAL. Brown.
ALONTAEL.
Yeah.
What's his middle name?
I don't get on it.
What is his birthday?
Deshaun.
Deshaun, how do you spell that?
I got his credentials in my house. 49 2000. I got it all in there.
You don't know your kid's birthday?
I know it, but
So what is it?
it's a 3. He's 3. Yeah. May 5th. 2010. Is he
2010 would make him like.
I know. I'm just trying to think. I'm just confused. 2018. Yeah. I got all that.
So what is it?
It's 2018. May 4th. It's May 4th.
5/4/18.
Yep. I'm just confused. Like this didn't have to happen when nobody typing or nothing. And my auntie should be.
How many kids do you have?
I have 3. I got 2 by her and 1 by someone else.
How many kids here?
Yeah, I do. Yeah, she said you told you that. This is my baby mama.
How many kids here?
It's just 1. He was
1 here.
Yeah, that's my.
2 with another lady who's not.
Yeah, they're older. This is my youngest. Yeah, she just walked around the corner. She works at the store. I went around the
Just
corner.
like I love another lady that ain't here. The other lady is right here.
Yeah, she
I
just looks
saw
like
you all
auntie.
that sitting right
No,
there.
that's my baby mama. That's my I got kids by her. So I just walked to the corner to go tell somebody because I thought he was going to get somebody. If we didn't fight, we didn't have no hand.
Okay, before I let you go with a child, I need just physical ID.
I don't
Got an
have no ID on me, so I gave you all that.
Do you have a Michigan driver's license?
I have it in the house.
But you do have a Michigan driver's
Yeah, I
license.
have it.
Go grab the ID for me,
But
please.
why do I have to do
Because
that?
I need to give positive identification before I can release the kid to you, okay? Couple
Yeah,
of issues I have.
that's right.
One,
I'm going to get you my custody thing. Nope, I'm going to get
go
my
get your ID too.
Yeah.
Hey, you don't even know your kids. You don't even know your kids.
No, because
I have no idea who you are. I have no idea who you are. Go get your identification.
But I know I'm all right, though. I know.
So just at that point, he's going into the house there. That's a fair statement. Where was the child during this period of time?
In the vehicle.
And how did the child get to the vehicle?
Injury brought her.
We're starting up here. We can see the defendant at this point. Is he returning from he's returning from the home at this point?
Yes.
Did I answer your question?
Yeah, no, it's not child neglect. I just walked right up to
Can
the
you
corner.
leave your kid at home alone?
Asleep.
Can you leave your kid at home alone?
I know, but he was
Can
asleep.
you?
No,
The answer is no. So did I answer your question?
But he was asleep. We just
Does not matter. Sleep or wake doesn't matter. You know that. Your father. You can't do that.
Come on, man. You act like I went to the mall or something. I did not go to the mall. I just went. I was gone 3 seconds. You know that's wrong, man.
What's wrong about it?
I know you're doing your job. I know you're doing.
Kids, help! I need help. I can't get out on the door.
No,
bro.
he can't even say that.
Yeah, well, you think I'd lie?
He can't see. He can't even talk like that. Man, that's some bullcrap. Yeah, he's going to sleep. He was asleep. I was at the door time. Because you guys knocked on the door. We came around here and saw you guys. And I like, hey.
So you saw us on
I saw her. No, I came back and I told her, I was like, well, the police, they're trying to probably take me to jail. So I had her come back. Because my auntie was here. She babysits. She's a crackhead. So I don't know where she went. I have her babysit. You have a crackhead babysitter? That's my auntie. I don't know what she does, but sometimes she leaves. She's a good babysitter, though. I don't know. Okay. Yeah. But the fact of the matter is, your son was at the door. Yeah, I know. Yeah, he always do that. They kids be over there like that. Oh, man, this is some bullshit.
I agree. I agree. It is.
You got
Yeah, yeah.
just make sure you tell him that I can take him to that.
Yeah, she got to, it ain't. So I'm gonna have a
We're about to be done once we verify your name, okay?
Yeah,
Sean, but hey, Sean isn't LaShawn. Okay?
I was giving all that, but you were just doing too much. I'm gonna have a talk for it.
It's, dude.
Fuck, man. Because I don't have to give my name. Like,
You do, absolutely.
was
Absolutely.
not
All
out.
day. 2 reasons. 1, I have to confirm your father. 2,
I am his father.
are you suspected of a crime? Yes. Child neglect. All day long,
That's
dude.
not child
All day
neglect.
long. We'll
No,
see what
it's
the
not.
prosecutor says.
It's
Okay?
not. They taught child neglect all day and I help their kids.
Listen, you wanted an education. You're going to get one today. Okay? You asked me a question.
I know what
answered
I'm
it.
talking about, man. It's all good, man.
By the way, whose dog? Little black dog's running
That's
around
my
back there?
dog. So you gonna take dog neglect too?
No, I'm just going to call it animal control.
Why?
Because you got an unsecured dog back there running around.
At that point of the video, do you make any more statements regarding the child, or is it start discussing about other matters? I am finished with the video for the time being.
Okay.
For flash drive over now and defense like this left as is.
Ms. Robinson, do you have a preference as to how you want that?
Doesn't matter to me, Your Honor.
All right, however you choose to proceed.
And after the conclusion of the video, did you stay on the scene for any period of time? Yes. About how long? At any point where you're on the scene, did anybody exit that house? No. At any point, did you hear anything from that house? Or what you heard from the child?
No. Cross-examination?
Yes, Your Honor. It's Officer Stelges, right? Okay. If I mispronounce your name, just let me know. So, you arrived on the day of the incident. You saw the child in question, didn't you?
Yes.
Okay. The child didn't appear to be malnourished.
No.
He didn't appear to have any scratches or bruises that you could see.
No.
He was not physically abused. And you could tell that he was properly clothed,
Yes.
properly diapered.
I don't know.
Okay, but he was properly clothed.
Yes.
Now you testify here today and on the video actually that you believe that the minor child was neglected by being left alone.
Yes.
Now that would mean that you would believe that there's a substantial risk of harm, correct?
Yes.
So, officer, when do you take a child into custody for child neglect? You take a child into custody for child neglect when there's a substantial risk of harm, don't you?
Yes.
Okay. In this case, did you take the child, the minor child into custody?
Yes.
Okay, you released him back to Mr. Brown.
Yes.
All right. So, officer, you did not arrest Mr. Brown that day, did you?
No.
Okay, and you didn't give him a citation that day, did you?
No.
And in order to do those things, you need to have probable cause that a crime was committed, don't you? Okay. But you failed to give a citation to Mr. Brown, correct? You didn't give Mr. Brown a citation for this incident, did you, on the day of?
We don't cite for child abuse offenses.
Did you take him into custody that day?
No.
Okay, so he was free to go that day.
Yes.
All right, and you interrogated Mr. Brown that day, did you not?
I question.
Okay, you were questioning at him. Is it fair to say that you were yelling a little bit, going back and forth?
No.
Based on that video. So what we just watched, you weren't yelling at Mr. Brown at all?
I was not yelling.
Okay, so just raising your voice, getting confrontational?
Very clearly speaking.
Very clearly speaking. Okay. So during this interaction, that's when he told you, when he left the house, his aunt was there, correct?
Yes.
Okay. And he also said that she told him when she left that she heard the police were coming, correct?
I don't remember.
Okay. Do you need to watch the video again?
We can. I don't remember what he said about the aunt.
I'll pull up the exact time frame, so just give me 1 second. You know what, I'll move on for the time being. We can address that in a bit. So going back, so he did tell you that his aunt was in the house when he left, correct?
Correct.
Okay, and that she eventually ended up leaving. Did he tell you that?
Yes.
Okay, and so then Mr. Brown comes back to his house, correct?
Correct.
Now, you previously testified that he was out for probably along 10 minutes, 11 minutes at the time that you arrived?
Correct.
Okay. And there was also another person at the scene that day, correct?
Correct.
And this person was Drake?
Correct.
Okay. And so they came back for that child as well?
Yes.
All right. And so when Mr. Brown told you that his aunt left, did you ever ask to see Mr. Brown's phone for any proof of that? Okay. So you never checked his text messages?
No.
And you never checked his call logs?
No.
Okay. And we just said that Drake also was there. Did you check her text messages?
No.
Did you check her call logs?
No.
Okay. Now, you never went inside the house that day, did you?
No.
Okay. You never decided to go get a warrant to go inside that house?
No.
Now, officer, it's not a crime to leave your child with another adult, is it?
No.
And let's say an adult who was in charge of supervising a child then leaves that child alone, they would be committing a crime, would they not?
Yes.
Okay. And they could be charged with child abuse as well.
Correct.
Now, officer, you've been a police officer for 6 years, right?
Yes.
And you're well aware that it's your duty to investigate crimes that you're made aware of.
Yes.
So you're trained to gather all the relevant information, all the details, including names, address, phone number, things like that.
Yes.
And that includes of people who, all of the people who would be potentially witnesses or involved in the incident at some point in time.
Correct.
Okay. And you create detailed reports of this, do you not?
Yes.
And you want all of this information because it's possible that it will be relied on in court one day, correct? Like we're doing here. And I'm sorry, I saw that you moved your head, but just because we have a court reporter here, can you just state your answer out loud, please? So on this day, you received information from Mr. Brown that he left his child in the care of his aunt.
Yes.
Okay. And that she wasn't there when the police arrived.
Yes.
That means she could be charged with child abuse fourth. Correct?
Correct.
You never asked Mr. Brown for her name.
No.
You never asked for her date of birth.
No.
You never asked for her address.
No.
What about for a phone number?
No.
And you failed to ask Drake for that information as well, didn't you?
Don't remember if I asked her or not.
Okay. So you state that you don't remember if you asked for the aunt's information.
Correct.
Okay. And what would have been shown in the body worn camera would be a fair and accurate. Okay. So if it wasn't in that body worn camera, then you didn't ask it.
Correct.
Got it. So you didn't do any sort of investigation onto who this aunt could be.
Correct.
Okay. And you didn't go into the house.
Did not.
And you didn't get a warrant to go into the house.
No.
All right. Now, officer, you would agree that sometimes people can be nervous around police officers, right?
Yes.
Okay. And you've been in situations where people have been nervous around you?
Yes.
Okay. And is it possible that sometimes people say things that they don't mean when they're nervous?
Objection calls for speculation.
Response?
Your Honor, I don't think it calls for speculation. He's been an officer for 6 years. I think he can testify as to how he believes the citizenry as a whole.
I'll sustain. That's pretty subjective that one person may answer a question in one regard and another person might answer it in another.
Nothing further, Your Honor.
Redirect?
Yes, Your Honor. So let's start off. You said there on cross-examination that you didn't take the child away because you didn't think it was a substantial threat of harm. At that moment, why didn't you think he wasn't a substantial? At that moment, why didn't you think the child was at a risk of harm?
Because the father was there.
And previous to that, why did you think the child would have been at harm?
There was no supervision. There was no way to open up the doors if there was an emergency. If there was an intruder, there'd be nobody to protect him.
And you didn't write a citation then and there, but did you file a report and submit it down the chain?
Yes.
And did you contact CPS regarding the matter?
Objection,
I would think. the door
hearsay,
was
uncharged
open.
conduct.
What legal object, what's the legal objection?
Hearsay and uncharged conduct, Your Honor.
I'm asking him what he did. I believe that the door was open to this by inquiries of why he didn't take the children.
I think it's a fair question as to what he did in regards to his investigation, which has been questioned under cross-examination. So you may answer the question.
Did you contact CPS regarding the matter? Just yes or no?
Yes.
And he did tell you that his aunt was there. He told you a number of other things. Isn't that correct?
Yes.
So he's on the video. He says someone's taking a shower. Is that correct?
Don't remember.
Okay. He says a lot of different things on the video. Is that a fair statement?
Yes.
And when he's saying all those things to you, are you thinking there's credibility to his aunt's statement?
Objection, Your Honor. Improper, calls for improper legal conclusion.
I guess
This
based
witness
on-
is not
may I
allowed to
rephrase, Your
testify to
Honor?
credibility.
Response?
May I rephrase the question?
You may.
Was there a reason after you heard those statements, you didn't think it was necessary to further investigate?
Yes.
And what was that reason?
I did not believe that Ann was there.
Why didn't you believe Matt was there?
We never saw an adult, heard an adult come or go from that home the entire time we were on the scene.
At one point, the defendant went back into the home. Is that correct?
Yes.
Did he come out with an ad?
No.
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Ms. Robinson?
Yes, Your Honor.
Without objection, the witness is excused. The people may call their next witness.
No further witnesses, Your Honor.
Do the people rest in this
Yes,
matter? All right. Before defense proofs, we should take at least a 5-minute break. And we'll allow the jury to take some time. And we'll come back in about 5 to 10 minutes. Okay, so the jury's excused at this time to go do whatever the jury needs to do. Okay, so you may leave. All rise. You're all right. Thank you, sir. All right, out of the presence of the jury, the people have rested. Does the defense have any motions that they want to make before we call back the jury?
Not at this time, Your Honor.
All right, so there's no motion for directed verdict. Did the defense plan to call any witnesses in this matter?
I'm gonna need a brief time to confer with
To
my
confer with your
client.
client, okay.
Yeah.
So we'll adjourn for counsel to consult with client, and we'll be back here 5 to 10 minutes.
Thank you, Your Honor.
Thank you.
Are you gonna see me? 'Cause I'm gonna go out there.
I was just gonna go briefly.
Okay, that's fine. Yeah.
So the first question I had is I have 3.3 already in there. So that seems, you're asking for that instruction. There's no objection to
Yes,
3.3.
correct.
We also had I'll take argument as to the indication which was previously discussed in chambers concerning there was a witness that was subpoenaed. Initially, they did not appear, and Mr. Wisty was going to indicate whether they were going to exclude that witness in some way. And then Ms. Robinson was going to make argument that there should be an additional instruction in regards to that witness. So Mr.
Timed out. Somebody here?
Are we timed out?
Okay. All right, so I don't think, with this case, the prosecution was the one who brought up all of these facts and brought up all of these facts about Drake, and that came out through their witness. They made those arguments at closing, and I think it becomes an issue now because this person was subpoenaed. I didn't have a chance to cross-examine them, and that's information where I could have gotten some more information regarding the case. They're not here. They're not here because they failed to respond to the people's subpoena. Therefore, I think the instruction applies. We don't know what she would say. We don't know necessarily what would happen. We do know the officer relied on what happened, and the state is now making arguments in their closing about what that person did. So the fact is that if they're allowed to do that and they're allowed to bring that in, I think I should have that instruction come in that says that that person was subpoenaed, they didn't appear, therefore we can infer their testimony would be favorable to the defense.
Response?
Your Honor, I just don't think that this meets the idea of the statute here. We had a witness who were able to talk about where she was, what we saw, things like that they physically saw. I don't think there was any commentary about any statement she made. I think everything was fair to infer. If she had been here, we would have also had a prosecution, assuming she did testify in the defense's favor. We would have an opportunity for the prosecution to cross-examine her. We're also without that. I just don't think this is a material enough witness. This jury instruction is warranted.
Okay, it's the court's ruling, and as I read the parts of Perez, but it may be appropriate, the instruction may be appropriate if a prosecutor fails to secure the presence at trial of a listed witness who's not been properly excused, or, and that is an or, where prosecutors fail to provide reasonable assistance. This is the first notice the court's had of this. There's indication that this is somewhat an after the fact witness, not during the witness. I think there's some relevance issue concerning the witness. I do not believe that 5.12 applies to this situation. So I'm not going to provide the prosecutor's failure to produce witness 5.12 instruction at this time. That's the ruling of the court in regards to the instruction. Any other arguments concerning any other instructions that the lawyers have had the opportunity to review?
Nothing concerning the instructions, Your Honor.
Anything else, Ms. Robinson?
Your Honor, I would just ask then for a limited or a limiting instruction that's given to the jury about how they can't infer anybody that wasn't here that didn't testify about, you know, what they said.
I think it's part of the instructions that they'll make their decision based on any evidence or lack thereof.
Okay,
And
well,
this is part of the lack thereof.
And I guess my concern would just be that if they decided that they came back and they wanted to watch the video per se, like I would, you know, be worried that they would take that or view that and.
I think they can only watch the video that's been admitted so far.
Yes, Your Honor.
Yeah.
If I may on that, I think it would be prudent if they do want to watch the video to call them in a courtroom.
Correct. And both counsels should be present for that. All right, let's have the jury back in. Oh, let's see the note. So we had a note after the fact by the juror. The question goes as to the cross-examination questions concerning text messages and calls that were requested from the juror, and the cross-examination was by Ms. Robinson. And there was an indication on the record that those were not looked into. So I think that's part of the lack of evidence, lack thereof.
Correct. So what's the question again? I'm sorry.
What text messages or calls did the defendant get? That was not part, that was addressed on cross-examination and not a part of the evidence.
Okay.
Because the officer indicated they did not look into the text messages or during. So I don't believe it'd be right to read the question. And it's somewhat answered on cross anyway, but there's that, it's a follow-up question. When you're ready, Nathaniel.
Do I give a Jen jury room?
They should take it in.
You want to hand it to them?
I'll give it to Nathaniel. Nathaniel can take it in once they're ready to deliver it. We just have to remember to tell them. All right, thank you for your patience today as we sorted through some of the jury instructions and arguments. You may now be seated, and I'll explain to you some of the final jury instructions before deliberation starts. Understand that after the jury instructions procedure, one of you is going to be picked off. All right, so you understand that. That's the alternate. Members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decisions. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. That is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said, what you decide about any fact in this case. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to instructions and some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the laws I give it to you, and in that way decide the case. A person accused of crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after careful examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I've told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence in each side's legal theory. You should only accept things that lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought, saw, or remembered. There's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that the witness said. On the other hand, if you think the witness lied about something but told the truth about others, You may simply accept the part you think is true and ignore the rest. When you go to the jury room, you may take along a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until recess. A verdict in the criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement, express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. The possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you are in the jury, please have the foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know where your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room, deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. We've decided that if you wanted to see the video that was previously indicated, that we would do that with the lawyer's presence on the video screen so that we have the right times marked, because there's been some discussion as to making sure that you watch the exact admitted that's been admitted, the exact portion of the admission. When you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions as the law you are to follow. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So taking that same example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself or by a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all the evidence that you believe. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards used to evaluate the testimony of any other witness. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you're not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the crime. He only has to prove that the defendant actually committed the crime. The prosecutor in this case must prove beyond a reasonable doubt that the crime occurred on or about September 18, 2021, within the city of Lansing, Ingham County, state of Michigan. The defendant is charged with child abuse in the 4th degree. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt: that LaShawn Brown had care or custody or authority over the minor child, that the defendant knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm or injury to the minor child. Actually, injury is not necessary, that the minor child was at the time under the age of 18. You may return a verdict of guilty of the alleged crime or not guilty. I prepared a verdict form listing the possible verdicts for you. And so what we're going to do now is I will excuse a juror, the extra juror, and then I'll have you go into the jury room. And I just got a note. I want to make sure that you get paid for your attendance here. So while we're sorting out, I'm going to excuse the juror. During that process, when we adjourn it, I'm going to have you go down to the Treasury Department and make sure you get paid because they close at 4:30. Okay. And so I don't want you deliberating past your 4:30 and then you got to wait to get whatever check. All right. So those of you who are still left on the jury, come back up and then we'll tell you when to start and we'll give you the jury verdict form. Okay. And then you can deliberate. We have previously selected a juror that will be the alternative jurors. So they are done for their participation today. This was chosen by lot, by both lawyers. And once again, it's juror number one. Juror number one, the hot seat for today's purposes. Ma'am, you are free to leave. Thank you for your appearance today. And if I were you, I'd go right to the Treasury office. Yes. The remaining jurors who will be deliberating this case, my court officer will show you where to go to the Treasury Department, which is on the first floor, so you can get paid and then come right back up to the jury room and we'll start deliberations. We'll provide you with jury instructions and we'll also provide you with the jury questionnaire form or the jury verdict form, okay? So I'm gonna release the jury at this time to go get their compensation, and then we'll see you back in the jury room.
Do we take our notes with us?
Yes, yes. You can take your notes, any notes that you have that will help you in deliberating through the case. And then I wouldn't speak to anybody about the case while you're in the Treasury Department, just to keep it safe. And then you can tell them where to go on the first floor.
Thank you.
All right, are there any, I'll wait for the jurors to,
So downstairs.
First floor.
Straight across from where the security is.
to the left.
So there's the mailroom on the left and
Says the
right
income
across.
tax
Yeah.
officer.
That's new. Are there any comments or other than the record that's already been made? Any comments on the instructions on this file docket 21-03378 from the people?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right. We'll wait for them to come back up and we'll start deliberations. And Nathaniel, when they get back, if you just give them the verdict form and tell them to start, they should be good, okay? All right, we're in recess for deliberation of the verdict.
Thank you. So, up to. So, yeah, no problem.
Just the foreperson. Thank you. And you may read the verdict of the jury.
The verdict is not guilty.
Okay, thank you. Thank you for your appearance today, everyone. It's important. As you may know, we kind of take this seriously. You've reached a verdict in this case. Thank you. You're all excused, okay?
Do we just leave our notes here?
Yes, you can leave everything here. And we'll make sure it's all taken care of.
Thank you.
And everybody got paid.
Yes.
All right. Thank you for your appearance today.
Thank you.